and welcome to TIOL Legal Wrangle on Corporate Laws with me, Anuj, joined by my co-anchor Kalyan. Let's get started for this episode's headlines. Major e-commerce sites blocked from selling the products of Amway and Oriflame. The Supreme Court restricts the applicability of group company doctrine by excluding non-signatory foreign companies during arbitration. Non-banking financial companies with valid RBI certificate are outside the scope of insolvency and bankruptcy code. Let's begin to dive into the details with today's cases.
Multiple suits for permanent injunctions against the Amazon, Flipkart, Snapdeal and Healthcart were filed by Amway, Oriflame and Modicare. Earlier, it came to the notice of plaintiff that health and wellness goods that were produced, marketed and distributed by them through a system of direct selling were listed for selling by unauthorized dealer in these e-commerce sites. Initial action to cease the selling of unauthorized sales by sending legal notice was straightaway denied by e-commerce platform by claiming immunity under intermediary status. The defense that was put up to negate the claim of injunction was that the defendant right to trade was anyway protected under Article 19(1)(g) of the Constitution. Amway and Oriflame called for the applicability of direct selling guidelines 2016 in India and claimed that since their products were sold specifically through direct selling contract by trained sellers directly to customers, the defendants not only were damaging the reputation of plaintiffs by selling expired unverified goods, but were also in violation of law.
Rejecting the defendants' defenses, the court primarily injuncted the defendants on two primary grounds. Firstly, the direct selling guidelines are operational since 2016 and they are even authenticated by a Gazette notification. If the guidelines are nullified, these entities would be left with no remedies to enforce a binding law. The uniqueness of direct selling guidelines required the e-commerce platforms to obtain the consent of direct selling entity before offering for sale their products. The fundamental rights of these sellers on such platforms are limited by the prior permit of direct selling entities, and hence no case is made that their fundamental right to do business was impinged in any way. Secondly, the right of trademark owners to regulate the sale of their respective products in order to ensure their economic value on e-commerce platforms overrides the right of e-commerce sellers.
Moving on, in international commercial arbitration, the group of companies is an interesting doctrine. It makes a non-signatory corporate party bound by an arbitration agreement. The consent to be bound by arbitration, expressed or implied, is a necessary factor. But what happens when branch offices in India enters into an agreement and another associated company who is in Belgium has no knowledge about it? Could the Belgium-based company be impeded as per this doctrine? Our next case holds this answer. The respondent company, that is Renders Labels India, which is a part of international group of printing companies named Renesco NV, signed a printing agreement with Reckitt Benckiser. After the dispute arose, the applicant Reckitt tried to make a case that another company in Belgium, which shares the common parent entity Renesco NV, must be impeded in the arbitration dispute involving the Indian counterpart of Renders. Based on this ground, application was filed under Section 11 to appoint a sole arbitrator.
Holding that it was not a case of international arbitration but domestic, the Apex Court held that the Belgium company was neither the signatory to the arbitration agreement nor had any casual connection with the process of negotiations preceding the agreement in whatever way. Therefore, even though it happened to be a constituent of the group of companies of which the Indian company belonged to, it cannot be subjected to arbitration proceedings on the basis of doctrine alone.
Moving on to the last case, a controversy has recently arisen as to whether the definition of financial services and financial service providers in the legislation is inclusive and limited to only those set of institutions which were named in clauses of Section 316. Whether management of securities involving financial products also comes within the definition of financial services. Let's see what the NCLAT held.
HDFC Bank filed an application against RHC Holdings for initiation of corporate insolvency resolution process after it defaulted in making payments on credits. RHC Holding contended that it was essentially offering and managing assets involving financial products, and as such, it is a financial service provider as per the IBC. Accepting the defense, the adjudicating authority rejected the application that as a financial service provider, insolvency resolution was not applicable in RHC's case. The appeal before the tribunal was made on two grounds. First, as to whether RHC Holdings' service of investing in shares, bonds, and debentures was financial services, and second, as to whether the ambit of financial service provider in IBC carving a specific set of institutions which provides identified set of financial services is a tight container and anything excluded cannot come inside.
Answering both the issues against the HDFC Bank, the tribunal firstly interpreted the definition of financial services and read it the definition of the financial services provider. It then held that it was not necessary that the financial service providers must accept the deposits. If any of the activity as defined under section 316, such as safeguarding and administrating asset consisting of financial products belonging to another person to render advice on or soliciting for the purpose of buying, selling or subscribing to a financial product and availing of financial services, they come within the definition of financial service provider. Another pertinent point was that the registration of certificate issued by the RBI to RSC Holdings was proof of carrying businesses of non-banking financial services subject to other conditions. From reading the definition of non-banking financial institution, financial institutions and non-banking financial company provided under section 45I of RBI Act, RSC Holding being financial service provider did not come under a corporate person as defined under section 37 of IBC. As such, it was outside the purview of IBC and application to commence insolvency process itself was found untenable.
That's it for this episode on corporate laws. If you want more of cases on Companies Act, capital market laws, competition laws, IPR, PMLA, FEMA and other cases, please log on to www.tiolcorplaws.com. Thank you for watching.